Hello, everyone. Welcome. I'm Doug Bennett, Acting Director of the New York Tech Alliance, and your host for today. With us is a wonderful and esteemed panel of legal minds and experts who will kick off the first in a series of events focused on helping tech companies outside the U.S. prepare for entry into the U.S. market. But before we get started, I'd love to know where everyone is joining us from. Would you mind saying hello and in the chat field, type in your city or country? Hey, Vitor, welcome. New York City, we've got London, Montreal, Toronto. All right, fantastic. Ottawa, Estonia. Hey, Estonia, welcome. And a couple more from NYC. Okay, fantastic. Well, glad you could all be with us today. Please know that we record our events and share the experience with those who are unable to attend. The recordings are posted on our YouTube channel. You can view this recording and past ones at youtube.com/New York Tech Alliance. For those of you who may not be familiar with the Tech Alliance, we're a nonprofit serving the New York tech community. Driving access, equity, and inclusion is at the core of our mission to help make the New York tech ecosystem the most diverse and dynamic in the world. One of our more notable events or other notable events is the New York Tech Meetup, a program that began in 2004, has grown to over 62,000 members, and has seen over 1,000 companies demo their tech products on our stage. For anyone who was able to join us last Monday for our first in-person meetup since March of 20, you can view the recording on our YouTube channel. And I'll post these links in the chat shortly. You can also view photos on our Flickr account. Thank you to our annual sponsors. We love our sponsors, and they help make events like this one possible. Each has a presence on our website. You can learn more about them and how they support our community by going to nitech.org/sponsors. And lastly, we love and welcome support to help us produce and deliver programming. 3 ways you can help include add a donation when you RSVP for one of our events, become an individual or corporate member, or simply make a donation. You can do so by going to nitech.org/support_NYTA. Okay, with that, I'd like to introduce today's moderator, Paul Ellis, managing partner at Paul Ellis Law Group, and one of the founding members of the New York Tech Alliance. Hey, Paul, welcome.
Doug, thank you very much. Again, welcome to all. Again, my name is Paul Ellis. I am a board member here at Tech Alliance. I run these series of events, legal events and financing events for startup companies. I run the Paul Ellis Law Group, a firm in Midtown Manhattan. So before we jump into content, this event is one of a series of events we have on various legal issues for startup companies. Past events have covered topics such as VC financing, intellectual property protection, getting ready for an exit and an M&A event, and other similar topics. All of those videos are available on the YouTube channel for Tech Alliance. They're also available on the resources page of my firm's website. I encourage you to take a look at those because there's a lot of useful information that startup companies can find through those videos. We will, before we get into content, we're going to go around the room and do introductions. We have a really great panel today. We have Alex Rubin of counsel to Paul Ellis Law Group. We have Michael Cerroti, founder and senior partner of Cerroti Law. Michael is an immigration lawyer. Alex is an employment lawyer. And then we have Jack Wilk, co-founder of Wilk Auslander, who is a tax lawyer. I myself am a corporate lawyer. So among the 4 of us, we are going to rocket through a lot of important material on this subject. So by way of introduction, I'll just start with myself quickly. Again, I'm managing partner of the Paul Ellis Law Group. We are a 10-lawyer boutique in Midtown Manhattan. We do a lot of work with startup companies in the tech space. We work with clients that are really looking for us to give them efficient legal solutions that free them up to grow their businesses. We work through the life cycle of issues facing startup companies, including formation, venture capital finance, IP protection, employment, general operations, M&A exits. We, as the lawyers in the firm, all come out of top law schools and major New York firms. That enables us to bring big firm expertise in a cost-effective way and the more personalized attention of a boutique firm. That's a little bit about my firm. With that, I will turn it over, in my practice, I will turn it over to Alex.
Hello, everyone. I'm Alex Rubin of counsel to the Paul Ellis Law Group, as Paul mentioned. Thank you for the opportunity to speak to you today about key employment issues in the U.S. I focus my practice on helping employers and employees resolve their disputes efficiently while minimizing disruption to their businesses and their personal lives. My goal is always to resolve the dispute first, or even prevent it from happening in the first place. I counsel clients proactively on policies and contracts that help prevent lawsuits whenever possible. Now, should employee misconduct be suspected, I will perform an internal workplace investigation. And should litigation be necessary, I represent either the employer or the employee in court. Just a little background about myself. I worked in public relations and journalism before going to law school, and then I graduated from the University of Pennsylvania Law School in 1996. I am admitted to 3 bars: New York, New Jersey, and Pennsylvania. Thank you.
Alex, thank you. Michael?
Thanks, Paul. Michael Cerati. I'm the founder and senior partner of Cerati Law Firm, senior because I'm the oldest guy in the firm. We have 30 people, including 7 lawyers. We focus on immigration. Our clients represent multi-billion-dollar international companies down to startups, and that's my focus, the startup environment. Been in it for about 10 years. We have a fairly significant presence in Silicon Valley, represent probably over 250 startup companies from early stage to where they go to Series A and Series B, all about immigration. I'm also counsel to Stanford's StartX, which is their accelerator, and I'm a partner in Unshackled Ventures, which is a VC based out of San Francisco. We invest in very early stage startups, business plan, where at least one member of the founding team has to be a foreign national. And I'll talk just briefly about the various options and sort of the journey going from, hey, I have this company in Germany and I look at the United States, I need to go there, I need to have my customers there, and how to get there and how to use immigration as a competitive advantage when you're recruiting for talent around the world. Thanks. Yeah.
Michael, thank you. Jack?
Hello, everyone. Jack Wilk. I'm the managing partner of Wilk Auslander LLP. We're a commercial law firm based in Manhattan. We have about 35 lawyers. I specialize in tax, and I've worked very closely with Paul we were trying to figure out many years, probably over 20 years. What I try to do is structure your investment. You're coming into the U.S. in the most tax efficient way. Whether that be Paul will talk about the corporate aspects of that, but the tax obviously fits very closely to that. I've been doing taxation for probably about 40 years. Don't mean to age myself. I started when I was like 10, and I've done all kinds of tax, but a lot of experience in international and companies going into the United States, and also companies going out of the United States. And I will give a brief presentation. We all have a limited time. I could talk for hours about tax, but I'll just give really high-level stuff. Thank you. Thank you, and nice to meet everyone.
Jack, thanks very much. And all of us will be around for the networking afterwards. Our contact information will be available as well. All right, so today, what are we talking about? We are going to we're going to center this on 4 topics that, in my experience, are the topics that are the first ones that when a client comes in, talk to me, they're coming from Europe, from India, from East Asia, wherever it is, there are certain things they want to talk about. In my experience, these are the 4 top topics: that corporate law, which includes choice of entity, jurisdiction, and other issues, tax considerations, employment law, and immigration. That's what we're going to focus on today. That's that's a lot of material. We're not going to be able to go into it in much detail, but we'll do the best we can. That's to say, there are other areas we're not covering that are not unimportant, but not at the top. There's intellectual property, data privacy, and cybersecurity, and frankly, other areas. But the goal today was, in my experience, what are the things people need to hear about most and are most interested in hearing? So that's what we're focusing on. So the idea we're going to each take about 8 minutes to initially go through this area. A high-level summary review of the principal points in each of these legal disciplines that are important to you coming to the U.S. We're not in a situation where we can give you all the answers, but we want to identify the issues. That is to say, we want to put you in a position that as you move forward in your plans to bring your company to the U.S., you're aware of what the options are. You're aware of the different types of corporate structure. You're aware of what type of visas may be available to you. You're attuned to the various important topics. So as you move forward, okay, I need to speak to a lawyer about this, or I have this consideration, or what have you. I will note there are cross-cutting considerations in all of this. So choosing a corporate structure and the relationship of the entities, it has implications in terms of tax considerations. It can have implications in terms of immigration plans for a visa. It implicates liability among the entities. So whenever you're making this decision about entering the U.S. market, these are all considerations you need to keep in mind so you get to the right result. Net, the most important thing is learn what you can from us today, but before moving forward, it is important to consult with a lawyer. All right, with that, let me jump into the first topic, the corporate law considerations. I'm going to start by noting about the U.S. legal system. We have a federal system here, meaning that we have federal law, but there's also state law at each of the 50 states. And so when you're coming to the U.S., it's not just a matter of the fact that you are coming to the U.S. You need to know, if you're forming an entity, which jurisdiction is it going to be? Is it going to be Delaware? Is it going to be New York? Is it going to be California? Because the law of each of those states differs, and this is differs from many other countries, and it's important to keep in mind because law in the U.S. there's some areas of law which are exclusively federal, like patent law, and there's some areas of law which are largely state or local, such as employment law. But then there are other areas which are impacted by both state and federal law. So that's to say, both state and federal law will apply. It's always something to be aware of, and one always wants to know what state law is going to apply, and that becomes an issue when you're entering into your contracts as well. So when you are coming to the U.S., an initial question you need to consider is whether you're going to form a new entity or whether you're going to operate as a branch of your existing entity in your overseas jurisdiction. Now, in most cases, the answer is that you are going to form a new entity. That's what most of my clients do. There's important considerations in terms of tax treatment, which Jack will talk about. There's also an important consideration in terms of liability, that if there are any liabilities that the local entity that your local operations are exposed to, if you have a local subsidiary, that will make it more possible for you to cut off liability at the local level without it flowing back to your overseas entity. I will say that Generally speaking, the choice is to form a new entity, but from time to time, I will have clients that say, well, we're just coming, we want to put one person on the ground, modest operations, we're not sure what the big picture is, and they will decide not to form a new entity. Doesn't happen that often because a new entity is generally your best alternative, but that the branch operation is a possibility that some companies take advantage of. The next question then becomes, if we can go back to the previous slide, please. The relationship of the new entity to the existing overseas entity. Generally, it will be a subsidiary, a wholly owned subsidiary of the overseas entity. But there are situations when you may consider making the local entity the parent entity, doing what we call a Delaware flip. You have a stock swap in which the original overseas entity becomes an operating subsidiary, and the U.S. entity, often a Delaware entity, becomes the parent. And that's often done in the case of VC investment, as that's a more VC investors will be more inclined, more comfortable investing into a Delaware corporation. So those are two alternatives. Putting the investment scenario aside, more often the new company will become a subsidiary company. The next question is the type of entity. The two choices that are most often used by companies entering the U.S. market will be a C corporation or a limited liability company. Now, Jack will talk about this a little bit more. While an LLC has a lot of advantages in terms of flexibility and also tax benefits in some exit scenarios, in this situation where you have a foreign company entering the U.S., often it's not the best choice because there's the potential of exposing the overseas entity to U.S. taxation. Jack will talk about that a little bit more, but for that reason, more often than not, when companies are forming a subsidiary here in the U.S., they will use a C corporation structure. We can go to the next slide, please. So once you know the type of entity that you're forming, the next question is, what is the jurisdiction of incorporation? People may be aware that Delaware is a very frequent choice for incorporation in the U.S., whether it's a corporation or an LLC. There are a number of reasons for that. There's a favorable tax regime in Delaware. The business law is very well developed, and so there's a higher degree of predictability for companies formed in Delaware. The court system is efficient and also predictable. The filing system for forming entities and for any types of changes is fast and reliable. So for these and other reasons, there is a strong predisposition to going to Delaware as opposed to other states. And even for companies, I mean, for us in the U.S., I'm a New York lawyer. I form far more, my clients far more often form their entities in Delaware than in New York State. Having said that, there are situations where you may form an entity in another state, but by and large, you will find that Delaware is a good and an important choice. I should mention then that just because you are incorporated in Delaware, that doesn't mean that's where your office needs to be or where your operations need to be. Excuse me. Companies will do business in wherever is appropriate. Many overseas companies will end up in an office in New York in the first instance, and because of the strong commercial center here. But it is very typical to form your entity in Delaware, and then wherever you have a presence, or what we call doing business, which is a term of art, wherever you have a presence, then you will qualify. You will register in that state to do business in that state. So very often I'll have companies entering the U.S. they'll incorporate in Delaware, they'll qualify in, say, New York. Now, I will say the process of incorporation and qualification is quite straightforward in the U.S. There are not, significant hurdles or hoops that you need to jump through. You don't need a U.S. director. Generally speaking, you don't necessarily need to have someone on the ground in the U.S. in order to form the entity. Sometimes that becomes an issue as you begin to get established and need banking relationships. That's the one area where we find that you may need to have someone on the ground, at least to open bank accounts. But for many other purposes, presence in the States is not necessary. With respect to ongoing compliance, there are annual franchise taxes to be paid, particularly in Delaware. There are income tax returns. Jack may speak a little bit more about that. That's at the federal, state, and local level. And then depending on the type of company, what type of operations you have, and where you're located, there may be other types of compliance as well. So if you have employees, there may be employment filings, payroll withholding. Depending on the type of business, there may be local laws you need to comply with, and others. But by this, when it comes to compliance, that really becomes a more specific matter of what type of company you have, where you're formed, and where you're doing business. And at that point, you really need to speak with your lawyer for more details. That is a high-level summary through the corporate law considerations. We will be doing Q&A at the end of the program. So with that, I will turn it over to Jack Wilk.
Hello, everyone. As I said before, I'm a tax lawyer. My presentation will follow very closely Paul's because we work together to determine the type of entity to set up or not set up. So I'm going to talk about some of the same things Paul talked about, but dig into it a little bit deeper. Just a general overview of U.S. taxation. Businesses are subject to tax at the federal level, the state level, and depending upon where you do business, in the city level. For example, a New York corporation would be subject to business. New York City corporation would have state tax, city tax, and federal tax. Although a lot of businesses want to come here, it's not necessarily the best place to do business from a tax point of view. Then when I get to the specifics of how you set up in the U.S., it's just like Paul said, that there's a choice between a U.S. branch and a U.S. subsidiary. I'm going to talk a little bit, because there's not much time, and the basic taxation of each and the advantages and disadvantages that they have. Can everyone hear me okay?
Yep.
Okay. And I'm going to talk about quickly the advantages and disadvantages. But at the end of the day, most people, as Paul said, will set up a subsidiary. And that's principally because if you don't set up a subsidiary, the foreign company has to file U.S. tax returns, and they generally don't want to. Even though in theory it's the same amount of tax either way you do it. But 99% of the companies that I deal with do not want to file U.S. tax returns. And that's usually the right choice not to. And if you're a branch, you would have to file a U.S. tax return. A branch would have to qualify to do business in the United States, in whatever state they're doing business in, like Paul said. If you're doing business on a high level thing, I'm moving to sort of treaty considerations. On a high level thing, you're considered doing business if you have a permanent establishment, which is generally an office. And if you're just selling into the U.S. and have no office and have independent contractors, a treaty will generally protect you from U.S. taxation, as will the general principles of taxation. So it's important to find out if your country has a treaty. From the countries that were talked about here, it sounds like most of you have a treaty. So that will define whether you're doing business in the United States. It will also importantly cover withholding issues. If a U.S. subsidiary makes interest or dividend payment to a foreign company, it's subject to withholding. So I'll go back a little bit to the advantages and disadvantages from a tax point of view. If you have if you set up a corporation, you usually have intercompany agreements which will establish the taxation. The intercompany agreements will pay for services or pay for goods. Generally, the U.S. corporation acts as a. If you go back to the previous slide. Generally, the transfer pricing, the contract will establish the amount of income subject to U.S. taxation. Generally, the U.S. company sometimes will act as a distributor, meaning they'll actually buy, depending upon your type of business, they will buy the goods and then sell them. Or sometimes the U.S. subsidiary will just be a sales arm. But if you do a U.S. subsidiary, the foreign company will not have to file a U.S. tax return. Another advantage of a U.S. subsidiary is that if it comes to a point where you want to sell the company, if you just sell the stock of a U.S. company and there's no FERPT issues, which is meaning you own real estate, that's generally not subject to U.S. taxation. And once again, there are many reasons it's the preferred form. The disadvantages of a U.S. subsidiary are, as I said, if you pay dividends, it's subject to withholding. There is a possibility, depending upon how closely related the U.S. company is to the foreign company. They may say the foreign company is doing business, but that rarely happens. And just as a general statement now, before I get into the taxation of brands, I just wanted to put it out there, is that in the day and age in the United States of remote working, where people work remotely, U.S. state taxation has become enormously more complicated. So, for example, you might have a U.S. office, but you might have people working remotely in 10 different states, and it becomes that's sort of a new thing. That's a pandemic thing that people are struggling with in the United States about the state taxation based upon remote workers. And as is the case generally in the United States when it comes to taxation, states are not consistent. They have different rules, so you just have to be very sensitive to state taxation and remote working, no matter which way you go. So if I talk about taxation of a branch, there's sort of two ways to be a branch. You can set up a wholly owned limited liability company, which Paul talked about, and for tax purposes, that would be disregarded, but you would try to do the business in the wholly owned limited liability company for liability issues. So in this case, as I said before, the non-U.S. taxation company would have to file U.S. tax returns, only pay tax on the U.S. business that's attributable to the permanent establishment, but people feel more comfortable with a subsidiary where they can have intercompany contracts and establish that number. And if there is an audit, the audit would principally be of the U.S. company. Foreign companies generally do not want the IRS poking in on their business, which is why, in my experience, similar to Paul's, 99.9% are subsidiaries. I'm checking my time. I think I've got about a minute or two. Yeah. So if I go, the principal advantage of a branch, and also there's something called branch profits tax, which is a branch is subject to. That's meant to be similar to the dividend withholding I mentioned before, but at the end of the day, it's much more complicated and potentially more onerous than the dividend withholding because it's much more difficult to control the timing. Once again, a treaty will impact that. So as I said, the first question I usually ask people is, I know what country they're in. We have to figure out if there's a treaty there because treaty generally makes everything much easier. The biggest advantage of a branch is that if you have startup losses, depending upon the foreign law, obviously you can deduct those, but on balance, it's always a corporation. You can do intercompany contracts. The foreign company doesn't have to file tax returns. I think everything is generally easier, simpler. It's as Paul mentioned, it's inexpensive. It's inexpensive to set up a U.S. corporation. So I'm going to just go through what I consider four reasons why a U.S. subsidiary is preferable. It's more easy to segregate the U.S. and non-U.S. income. It will likely limit the amount of income subject to tax. It eliminates the requirement of the foreign company filing U.S. tax returns. and it involves dividend withholding rather than branch profits tax. Other things to consider, and I'm sort of capitalization of the U.S. company, debt versus equity, depending upon the treaty. For example, if there's no withholding on interest, a lot of companies use debt to try to get money back to the home country through interest. There's a lot of rules in the U.S. concerning related parties and interest. I could talk a whole 2 hours about that, but I don't. Another thing to always consider when you're setting up a U.S. company and a foreign company is please go to the next slide. Is transfer pricing. So transfer pricing basically means that even though you're a related party, if you're selling goods from the foreign country to the U.S., it has to be on an arm's length basis based upon what a third party would do. And presumably your home country also is concerned about transfer pricing. For startup companies, it's usually, they don't really fuss that much with transfer pricing, but bigger companies, when I say fuss, there's, the technically right thing to do is get formal studies done about what the fair market value price is. But for a startup company, that could be cost prohibitive. So they just look at the market and decide if they were selling to a third party, how much would they sell it for? And then the third party, of course, the U.S. company will then make profit by selling it for more. So transfer pricing, once again, is a contract all to its own. Then the thing to always think about in the U.S. is even though the foreign company isn't doing business in the U.S., there are many, many reporting requirements triggered by doing business in the U.S. and having a U.S. subsidiary. In the old days, innocent mistakes, and there's pretty big penalties. In the old days, innocent mistakes, usually you could say the U.S. would waive any penalties. My experience in recent years has been that the U.S. is much tougher on penalties. So although we don't have an accountant here, another consideration is when you're doing business in the U.S., make sure you have an accountant that is familiar with doing business in foreign jurisdictions. Otherwise, you might miss some of these U.S. reporting obligations, and the consequences could be large. Just trying to run through. So I think that. So I'll wrap it up by saying, on balance, most companies set up a U.S. subsidiary and establish intercompany contracts to try to fix the amount of tax subject to a U.S. subsidiary. Always be concerned about state taxation and, as I said, sometimes local taxation. But on balance, it's going to be U.S. subsidiary. But how you finance that with debt and equity and other things is very important from a tax point of view. So, as I said, I've worked very closely with Paul in making sure we minimize the tax. But sometimes the U.S. tax rate's higher than it depends upon it depends upon your the taxation rate of the foreign company. It could be higher than the U.S. So sometimes you want to push more income to the U.S. So each circumstance is different. The U.S. has recently lowered its taxation, so it's become much more friendly for non-U.S. people. And with that, I will wrap up. I will be in my table afterwards if anyone has any questions. And I went very quick, and I apologize for that.
Jack, thank you very much. That was a hurried,
very hurried.
A tour de force, though, nevertheless. So a lot of material, a little bit of time. Alex, we'll turn it over to you. Alex, we may be having connectivity problems with Alex. If we don't.
Hi, everybody. Here.
Alex?
You need to know about employment law in the U.S. when you're doing business here. So first.
Yeah, no, Alex, it seems to be a connection problem.
Means for any reason or no reason, so long as it's not.
Alex, we're not able to hear you.
Paul, if you could move on to the next.
Michael, why don't you go and Alex, you can work with Doug on your connectivity, or maybe you could dial in. Michael.
Sure. Thank you. Listening to you, Paul, and Jack, I'm wondering, do you really want to do business in the United States? But I've been doing immigration for 30 years, and I can assure you that there is still a huge demand because this is the country that is about business. And it's fascinating. Over the 30 years, I've seen a lot of technological advancements. When I started, you used to do one of these seminars in like a room, and people would have to logistically come into the room and you talk. Now we have people from all over the world listening in, and it's pretty cool. And unfortunately, the U.S. government doesn't really move quickly with technological advancements, and let alone immigration. For example, it's very antiquated, right? There are artificial barriers dealing with the government wanting the best, the brightest, the richest. But despite that, if you have an understanding of how immigration law works and you have good counsel, it can be used as a competitive advantage. And I just want to take you through a short journey about what that might look like today. So on my slide, you'll see we have a B1 business visitor visa, and perhaps people know about B's and L's and E's and so forth. There's really no relationship between the letter and the type of visa, but often you might have a business in Canada, for example, and now you've grown that business, and the US is a typical market. Well, what can I do to go in and investigate whether or not I'm in a position to either take the company to the United States or me personally go in there and start the business? Most important, as a business visitor, you have to maintain your residence and employment abroad. It's pretty easy. I own a house and apartment, and I'm employed by my foreign, let's say, Canadian company. Number two is, what is the purpose of my trip? Those people who have entered the United States, you always get questions from CBP officers, Customs and Border Protection. They're standing there, they got their guns, the uniforms, they look very intimidating. As long as you understand what you can and cannot do as a visitor, even if you're considering starting that business, you should be fine. What does that mean? Well, you can certainly come into the United States and you can check out office space.
Doug, is that you?
Meet with lawyers. You can meet with accountants.
Yes, I'm here.
You
I
can
can't
meet with
believe this is
VCs.
happening.
You can make pitches to angel investors, right? When Paul forms your company, right, and you get advice from Jack about taxes, you can be a shareholder and you can be on the board of directors of that U.S. company. What you cannot do as a visitor, and what you should not say to an officer, is that, hey, I'm the CEO of the U.S. company. Because by that, you're telling them you're working in the United States, and the visitor status does not allow you to work. You can also not say that I'm going in there to hire and fire people, right? So it's semantics, but you have to be aware of that. Most important, again, is you have to understand what you're going in for, what the purpose is, and you want to have that documented by an email exchange with your lawyer, your accountant, some VCs, and perhaps a round trip ticket from Toronto to New York and back. Once you've decided that you, as a co-founder or founder of a company, or as your company has grown, that you want to have a real physical presence in the United States, the question is, how do I get there? And what is the best visa for me to do what I want to do? So as you can see, if you're holding an executive position or you're going to hire and fire people, you got to have a work visa. And the U.S., again, is somewhat discriminatory about the visas that they offer to citizens of different countries. We like Canada. We like Mexico. We like certain citizens of what we call treaty countries. And there are other countries where we don't have good relationships with, either dating back to pre-World War II or even today. But normally, if you're, let's say, a Canadian citizen, you might want to consider getting an E1 or an E2 visa. I think the E1, E2 is probably one of the best visas that an entrepreneur can get. Why? Because it gives you the most latitude to grow your business. You can be the CEO. You don't have to have any educational background. You don't have to have any experience. You could literally start your company in the United States if you really wanted to. The only requirements in terms of, let's say, an E2, which is an investor visa, is that the U.S. entity must be controlled by citizens or a group of citizens from the same country. So let's say you're from Germany. That means at least 50% of the U.S. company must be controlled by German citizens. And I use the word control because often in my business, in the startup business, you may have a founder from the United States and a co-founder from, let's say, Romania. It's 50-50. You raise money and there's an equity dilution. Well, all of a sudden you're below 50%. You can use a voting proxy to raise your 45% ownership up to 50%. So control is an important factor. But in terms of the E2, there's really no minimum investment that's required. You just have to invest in enough to demonstrate to the officer that it's going to get the business going. And number two, you got to show you've invested the money. And number three, you got to show you're creating jobs in America. And those jobs can be direct employees, be contractors, or they could be vendors. Let's go to the next slide for a minute.
Okay, I'm muted. Okay.
Oh. Hey, Doug, can we go to the next slide?
Do you see where I am?
We got a sound issue. Thank you. So if for some reason the E2 doesn't make sense, we can't seem to get to the next slide. Next slide, please. There we go. Another option that we have is what we call an L1 visa. That's an intercompany transfer. So in many instances, you may have a diverse ownership structure and no one group of citizens can control it. But the company's been operating outside the United States for more than a year. If that's the case, perhaps the L1 intercompany transfer visa would be best for you. What are the requirements? There has to be a qualifying relationship between the foreign entity and the U.S. entity. What does that mean? That means it could be a parent subsidiary or a subsidiary parent. It could also be where a shareholder or the same group of shareholders control both entities. And it can also be a branch office. The other requirement and the distinction between the L and the E is that for an L, you had to have worked for the foreign entity for at least 1 year out of the prior 3 years before you file the application. All right. And number 3 is that you have to have filled some sort of executive, manager, or specialized knowledge position. So we're usually talking about executives and managers. There's no minimum investment required. You do have to have a physical office in the United States, and you do have to demonstrate in a summary business plan how you're going to grow that business. If it's an absolute new office, you're going to have to demonstrate how you're going to do that over the next year. If you've been operating for more than 1 year in the United States, or you acquire an existing business, you can get a visa for 3 years initially, up to a total of 7. A couple other visas that are available, right? Other than the E and the L, the H-1B lottery. I'm sure people have heard of that before. It's somewhat limited. It's somewhat limited in that you as a founder or a key executive have to join a lottery that takes place in April. And you also have to have at least a bachelor's degree. And in some instances, if you have a large interest in the company, there might be an employer-employee relationship issue. If that's the case, perhaps the O1 visa might be available. The O1 is people who have outstanding ability in their field. It's very subjective, but there's 9 criteria that you could meet, not 3 of which you have to meet. And you submit that application demonstrating that you're actually one of the best, not the best, but one of the best. You're outstanding. And you can demonstrate that by high salary, speeches that you've given in public venues. Perhaps you invented some software, you've commercialized it. The O1 visa is an excellent visa for entrepreneurs if they can't otherwise qualify for an E visa or an L visa, and the H-1B lottery isn't available. Also, there's some countries that are favorable. Canada and Mexico, we have something called a TN visa. Very easy, very inexpensive, very quick to obtain. We also have special treaties with Chile, Singapore, and Australia. those visas are similar to the H-1B, but you're not limited to the lottery. I mean, just like Jack and everyone else, we can go on and on. I'm available after this presentation to answer any specific questions. But that was an overview of the immigration. Thank you.
Michael, thanks very much. Here's the slide.
Well, we'll let it too. We'll say the government was handling the slides, so they were a little slow.
There it is. So, Alex, do we have you now?
Yes, you do. I'm keeping my camera on.
Okay, great. Alex, are you there? Alex, we still are not hearing you. Doug, any thoughts?
Hey, Paul. Yeah. Can you hear me?
Yep.
Yeah. So it's a bandwidth issue on Alex's side. So she's having it both with her computer and her phone.
All right. Well, okay. Alex, try again. Nope. Okay. So, well, we have
Well,
Alex.
let me pause for a moment. Just give me one moment, and I'll come right back.
Okay. Yep. We can take a couple of questions, maybe. If people have questions, they can put them in the chat. That's how we will. Michael, there was a question for you. The time limits for the B1, what are the time limits for periods of residency in the U.S.?
Sure. So generally speaking, think about 6 months, right? Because 6 months and a day, you're physically in the United States more than half the year. It's not a hard and fast rule. Often, if you come into the United States with a B1, B2 visa, they're going to give you 6 months automatically. If you happen to come from a visa waiver country like England, France, Germany, Czech Republic, you get an automatic 90 days. And the time limit, because we do get, I mean, during COVID, we had clients who came in as a visitor and Australia was completely shut down and they couldn't get back. And they were in the country in some cases for more than a year. The key in those situations, if you get stuck or if you need more time, is never let your time run out, because then you're basically up the creek without a paddle. What you can do is you just file an extension at the service center. So before your status expires, you file an extension telling the government, hey, look, I need more time to do what I'm doing. It takes them 6 to 9 months to process those applications. So in effect, you can be legally in the United States well more than 6 months if you do it the right way.
Just be sensitive to U.S. taxation and count your days.
Yeah, that's true. You always have to speak to the tax guy.
You always got to think about taxation, and once you're going to treat it. Sorry to interpose.
Hey, Paul, we're gonna try something unconventional, and Alex is going to try and speak with us through a different means. So she's going to make another attempt here.
Okay.
Okay, sorry for the technical.
I guess that's not working either.
Doug?
Okay, Paul, we gave it our best shot here
I
on.
see it happening. Okay, let's leave Alex's first slide up. I can hear you Jack?
Clearly right now.
Yeah, we can hear you, Alex.
Try doing it through the. See if that works.
You want to give it another whirl?
Yep, let's give it another whirl.
Now unless I'm hearing it through the phone.
Hey, Doug, this isn't happening.
Yep.
Okay. So Jack, there's a question. Alex,
what you need
it's
to
not
know
gonna
about
work.
employment law when you're doing business in the
We
U.S.
can't hear you.
Here.
Let's leave Alex's first slide up.
Absent a
We'll
contract,
do,
employment is
we'll do a
at
little more
will,
Q&A.
which
We can go
means
to her
you
second
can
slide
leave
in a moment.
or
Um,
reason.
Jack,
So
there was a
long as it's
question.
not
How
a
long does it take
discriminatory
for
reason.
an ITIN?
That's why
don't think you're
it
hearing
varies.
me.
It's much slower now, but depending upon your circumstances, sometimes you can do it online and get it quickly. As everyone knows, the IRS is understaffed and everything takes a long time. So I can't specifically answer that question. Quite frankly, the following of the ITIN usually is done by the accountant, not the lawyer. So I don't have that much experience there.
Yeah, I'd say that's generally the case. When we do the formations, we suggest that our clients work with their accountants on that.
But
I
quite
s-
often, if you have
the-
US, if you have, like, for example, if you set up a U.S. entity and look for a taxpayer employee number, if you have a U.S. resident, it's far easier. And sometimes your lawyer or accountant will be an officer to accomplish that purpose. I don't know if that's.
I would add that in almost every visa instance, other than the visitor visa, the U.S. company needs a federal employer identification number. So that is something that you need to get going relatively quickly.
Although, again, it can be done quite quickly. It's just a matter of getting it done.
It can be done quite quickly if you have a U.S. person doing it.
So it is. There's a question from Vitor Bruno more about digital business. If you can, in the chat, tell us a little bit exactly what the question is. I'm happy to do our best to answer it. I'm looking for other questions. Doug, can you advance to Alex's next slide so at least people can take a look at it?
Just to talk about employment issues and how it ties into tax, one of the prior slide talked about independent contractors versus employees. You have to be very careful in your discovery stage, if you will, if you haven't set up a U.S. company, whether or not you have employees here, independent contractors. Alex would have talked about the difference, but from a tax point of view, there's a huge difference. If you have an employee versus an independent contractor, their presence in the U.S. may be a permanent establishment, which possibly subjects the non-U.S. entity to taxation. So just be very careful about if you start, before you come in, start getting consultants and how much control you have over them and all those other things. So because you don't want to subject the foreign company to U.S. taxation prematurely.
Yeah, and I would say, generally speaking, the issue of independent contractors versus employees is an important one in the U.S., and the states have been far more aggressive in recent years on that topic. It is not it's a common startup dodge to treat everyone as independent contractors, but regardless of what you call them, that's not what's important. It's the type of work they're doing, the manner in which you're supervising them. I mean, there are many factors in that test, but it is important to get that right, because if you get it wrong, you'll be hearing from the Department of Labor, and Jack has outlined other consequences.
Yeah. It's funny, there's an immigration consequence to that too. Many of our clients have foreign companies, and they engage their distributed network of quote employees as independent contractors. That can be an issue when it comes to an L1. There are, interestingly enough, the tax definition of an independent contractor versus an employee applies in the interpretation of immigration law. So often, even though you may call them an independent contractor outside the United States, which a lot of founders do initially when they don't have a lot of money, if you're under the control and supervision If you have the company email, you're on the company Slack, you have an IP transfer, you have a non-compete, all those criteria goes into determining whether you're an employee for immigration purposes, which gives you more options in some instances for visa coming to the United States.
And I'll also note, I mean, this is touched on another issue, really a tax issue. To think ahead, as founders, you're getting equity comp, often getting equity comp or key employees in your entity. If you are getting that compensation while you're abroad, you may not be thinking what the consequences are under U.S. tax law of receiving that compensation. And then if at a later point you then come to the U.S., your alternatives may be limited. So if you're abroad, there's a likelihood or at least a possibility that you're moving to the U.S. Do consult with your lawyer and your tax professional about what the implications are of receiving equity in a U.S. company if you may at some later point come to the U.S. Jack, I'm thinking we've had issues.
We had that issue, correct? Yep. So
with an 83B filing that
absolutely.
Had when a founder abroad had a Delaware corporation, they received equity in the Delaware corporation abroad. Didn't do the filings. It's called an 83B filing that one would do if one were in the U.S. and governed subject to U.S. taxation. Then later came to the U.S. and it was too late to do that 83B filing.
Right.
So anyway, these are you need to think again. All of these areas are interrelated to some extent, and you need to be thinking proactively about what the future may hold, so you make correct decisions as you go. We are out of time. We got to many of the questions. I see we didn't get to all of them.
Yes, Paul, I see one more question.
Go ahead.
No, I see it for you.
Advantage and disadvantage. Well, I mean, I generally speaking, I mean, look, let's talk about quickly New York and Delaware. When we're talking about contracts and the governing law and contracts, commercial agreements, generally speaking, we would want New York law to apply because of the well-developed commercial law in New York. But when it comes to forming an entity and the law that's going to apply to that entity and to the operations of that entity, that's where you would want Delaware law to apply. That is not to say that New York law or California law is significantly failing in any of those regards, but generally speaking, Delaware law is a better more effective law for entity formation. All right. With that, we are going to have to wrap. Alex, I'm sorry we had issues with you and your sound. Alex's slides are here, and this video is going to be available. We will be distributing it, so you'll be able to see it again, and you'll be able to please feel free to forward it on. All of us are going to be in the networking area afterwards, so if you had questions for Alex, she'll be at a table, and hopefully she'll be connected and able to speak with you. And the contact information is in the chat. I will mention I have a Calendly link as well. If anyone would like to set up an appointment with me, feel free to use my Calendly link in the chat. Otherwise, we will see you in the networking area. Thank you to all the panelists. A lot of great content in a short amount of time. And thank you, and we'll see you all soon. Take care.
Thanks, Paul. Thanks, Michael, Jack,
Thanks.
Alex. We'll see everybody on the other side in the networking area.
Thank you, Doug.
All right.